Judge Coleman? Good morning. The 36th District Court in the state of Michigan is now in session with the Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing gum, or reading any materials, also no driving. Thank you. Good morning, Judge.
Thank you. Good morning to you. Court now calls case number 24-17-143. This is Rodnick Chiropractic versus State Farm Mutual Insurance Company. Your appearance for State Farm, I know that a counselor for State Farm is here. Your appearance, please.
Ashley Van Dyke, Your Honor, for State Farm.
All right, thank you, Ms. Van Dyke. Go ahead and put your P number on, if you will.
Yes, 84322.
All right, thank you. And I know that someone was indicating from Mr. Fortner's office. My understanding is that this matter has been resolved and that it should be closed out. Is that correct, counsel?
That is correct. We just got the signed release. I was just waiting for Fortner's consent to file the dismissal.
All right, and do I have someone there from Mr. Fortner's office? All right.
Yes, Your Honor. I apologize. Yep.
And what is your name?
Dree, I'm Mr. Fortner's assistant.
All right, Ms. Dree, tell me your name.
Dree West.
All right, thank you, Ms. West. Ms. West, I'm going to go ahead and acknowledge that this matter has been resolved, and I'll allow counsel to go forward accordingly. If there are any problems that arise, then the court will take that up in the future as on the motion to reinstate or something of the like. But it appears the matter has been resolved, and I will accept the order disposing of the matter. Thank you. Good day to you, Ms. Van Dyke.
Thank you, Your Honor. Have a good day.
Thank you, Your Honor.
The court now calls case number 22-177862. This is LAFCU versus Daquan Gatson. The matter is before the court on the issuance of a subpoena. That matter is set on for 9:30 a.m. For LAFCU.
For Lansing, for LAFCU, Tim Smith, P48259. Good morning, Your Honor.
Thank you, Mr. Smith, and good morning to you as well, sir. I am looking for Daquan Gatson. The record should reflect that the court did issue a notice from the court regarding the subpoena hearing. Counsel, were you able to get the subpoena served as well, sir?
We were, Your Honor. We served it alt service. The court file should reflect an affidavit from the court officer wherein on February 16, a female at the address in question confirmed that the defendant lived at that address. Alternate service was perfected at that same address.
All right, thank you. And I do see the application for alternate service. I see the affidavit in that regard as well. All right, so it appears that Mr. Gatson made the decision he's not going to appear at this time. Your motion at this time, sir.
Motion to file a show cause as it relates to this matter. We'd also ask that service be accomplished on the show cause order via 9-day mailing to the same address that we know he resides at.
Very well. The court will issue a show cause in this matter in order that the defendant appear for the show cause and basically failure to appear in this hearing. That show cause hearing is going to be set for the the 30th of June, June 30th, Monday, June 30th at 9:30 a.m. So submit your application with that date on the council will sign.
We will, Your Honor. We'll have the Zoom information as well on there or in person in the alternate.
Right, thank you. Thank you, sir, and good day to you. I won't be here then. I'm moving on. This is,
Okay. Best of luck wherever you're moving to, Judge. Thanks for your help this morning.
Day to you. Right, the court now calls case number 24-162-569. This is Woodland Villa Apartments LLC versus Christasia Payne. The matter is before the court, set on for a status conference. The court previously entered an order dismissing this matter. It was a petition for reinstatement. The court did reinstate the matter and set it for a status conference on today's date. Your appearance for Woodland.
Your Honor, Lee Meldy, P83783, appearing on behalf of the plaintiff.
Thank you, Mr. Melody. Good morning to you, sir. Do I have Christasia Payne on the Zoom? Ms. Payne, if you're here, please say something at this time. I do have the matter set on for 9:30. It is approximately 9:50, and I have a notice that was sent to Ms. Payne at her address on Beechwood in the city of East Point. That is the address that she has used throughout in regard to this matter. She provided that same address in her letter that was treated as a response to this matter. Counsel, any information that you have at this time?
I'm not aware of, I haven't had any discussion with Ms. Payne. I know she hasn't filed an answer. She has been served, but the reason for that, the motion today is to reinstate the case because it was dismissed for failure to appear for both parties. But plaintiff's reason for not appearing was we'd never received a notice of hearing. So I think the court can understand why we wouldn't have appeared for that. But as of today, we're asking that the court reinstate, we'll set aside the default and reinstate the case.
All right, the court issued an order on the 27th of March reinstating the case. And that's why I set the status conference today. The case already reinstated. So I believe that you're moving for entry of default. So what happened is there was a letter that was sent to the court, which the court treated as a response or as an answer in this matter. That was pleading, but the defendant is not here. Counsel.
I would move for default then, Your Honor. I will say we didn't receive a copy of the letter. When we filed this motion, we set a notice of hearing. And I didn't know that the court had entered an order in this. I mean, I could have checked the ROA, but my office hasn't received the letter and my office hasn't received the order for granting the motion to reinstate the case. But if that's the case that the court did reinstate, I would ask that default be entered today.
Yes, just to set the record, on the 24th of February 2025, the court did enter an order of dismissal indicating that neither party had appeared for a status conference that had been set by the court. Court subsequently received defendant's motion, ex parte motion to set aside the dismissal in this matter. On receipt of that motion, the court had read the motion. The court then on March 25th, 2025, strike that March 27th, 2025, the court then granted the motion setting aside the dismissal and reinstated the case. And the court then issued a court date on that same date. And that court date is today's date. That's the history on the file to the extent that the orders did not catch up to either party in this matter. That is what the file reflects. So today is a status conference hearing, and all parties have been notified of the same. For that reason, I will grant the petition for entry on default where defendant Payne has not appeared, where the court previously accepted her letter that was sent to the court. Her letter was in the form of a motion to dismiss. I accepted that as her answer for purposes of setting the hearing. She has not appeared. Default will enter on the failure to appear. You may submit your order consistent with counsel.
All right, thank you, Your Honor. Thank you for clearing that up also.
Thank you. Right, the court is now calling case number 24-1474. This is Victoria Brown versus Freddie Blanco. The matter is before the court set on for a pretrial conference. The court previously issued a scheduling order regarding this matter. Do I have any attorney involved in any part of this? If you are an attorney, your appearance at this time.
Jim Gorman, P40438 for the defendant.
Thank you, Mr. Gorman. Good morning to you, sir. I'm looking for. Thank you. I'm looking for Victoria Brown now. If you're in the Zoom, please say something.
Speaking. I'm
All
here.
right. Thank you, Ms. Brown, and good morning to you, ma'am.
Yes,
Counsel,
thank you.
all right, counsel, update me on where things are to the best of your knowledge, sir.
This is resolved. Actually, it was resolved almost 2 months ago. I sent a settlement agreement and dismissal to Ms. Brown, but she didn't sign it because there was a typo on her name. And unfortunately, she called someone at my client's office and the message that
I
and
lost you there.
okay.
You said there was a signed agreement. The name was misspelled or something. What else is there?
So I'm sending her a new one with the typo corrected. So hopefully I'll have that back within the week and, get this dismissal filed.
All right, sounds good. Ms. Brown, that makes sense to you as well?
Yes, they just spelled the name wrong.
All right. I will indicate on my notes then that the matter has been settled and resolved, and the court is just waiting on that order to be submitted so that this case can actually be dismissed. All right. So I look forward to that. And that'll be the end of this. Okay. Good day to both of you.
All right,
So
thank
I'm
you.
just waiting on the paperwork to come through the mail and I sign it and then send it back.
Yes. That's correct, ma'am.
Okay. Well, I'm waiting on it to come through the mail then.
Right. All right. All the best to you, Ms. Brown.
Thank you, and I appreciate you.
Right.
Okay.
Good day, counsel.
Okay. Appreciate you. Bye-bye. Yeah, it was nice. Treated me nice. Now what I do? Hang up?
Yes, ma'am. Just hang it up.
Okay. Did I?
This is case number 25-142089. This is Grand Transportation Services LLC versus AAA Insurance Company, doing business as Auto Club Insurance Company. The matter is before the court, set on for was reset for today's date. Looks like a pretrial conference. Right, your appearance for either party on this matter? Any attorney? We'll come back to that. All right, this is case number 10-129379. This is Midland Funding versus Brian White. The matter is before the court on a motion to stay garnishment. Anybody present on this matter at this time? Right. Record should reflect that a date was issued in this matter, April 24th, setting on today's date for hearing the motion. We'll call this matter momentarily. Looks like on these two matters that no one has appeared up here as witness. Keep your voice loud.
Didn't understand why the assistant didn't answer before.
Right, for the other case. But this
She knew
one,
about it.
yeah, probably didn't even know. And again, neither party is here for that. Most likely, and that happens frequently. Support is always most likely in that case, two of them don't have patients. So what I'll likely do with that one is just set it over for a couple of weeks, give it a adjourn date. See what happens there. So, yeah, so on that one, that's the stuff, it's 2089. We're gonna set that over for a couple of weeks to issue a notice. All right, in relationship to the suffix 9379, neither party has appeared on this matter. The matter was brought on a motion to state garnishment. And the attorney, Mr. Todd Perkins, did file this motion. And the heart of the motion is that this judgment that was entered on 5/16/11, that the judgment is expired, and that therefore execution cannot be had on the judgment that was issued, because 10 years expired. However, file notes that on 5/10/21, the court renewed the judgment in this matter within the 10-year window where the application was made. Based upon the factual scenario contained in the court's file, the judgment was renewed not later than 5/10/21. That would have been within 10 years period for renewal. With that being the case, the motion does not exist on solid grounds. The motion would have to be denied because the judgment remains valid at this time. So we should order consistent.
Judge, is that the case ended in 379?
Yes.
All right, thanks. Are we finished with, brand transportation?
It looks like they're coming in.
What'd you say, Judge?
Let me hit this, see, I think, sorry. Madam Counsel for Midland. All right, I previously.
Yes, Your Honor.
I previously called that matter under suffix 9379, Midland Funding versus Bennett White. Your appearance at this time, please.
Yes, Your Honor. Dawn Marie Ozog appearing on behalf of Midland P 63290.
All right, thank you. And I called this thinking it was 9:30, and I see now that I have it set for 10 o'clock p.m. I don't see the other side here representing Mr. Wedge. So I'll give it a few more minutes. I have reached a preliminary conclusion on this. I didn't see either party here, but I'll address that in a few minutes. I knew it's just after 10 a.m. So I'll give it a few more minutes and I'll come back. That's just to see if the other side is going to check.
Sorry, Your Honor, I can't hear you.
Oh, I'm sorry. So I'm passing on this for just a moment to see if the other side is going to check in. I thought earlier that it was set for 9:30, but I see it's set for 10 o'clock a.m. and it's 5 minutes after. So I'll give it another few minutes and then we'll
Okay.
come back to it.
Thank you.
All right, we're back on the record in 10-129-379, Midland Funding LLC versus Bennett Weich. The record should reflect the matters before the court. On the plaintiff's strike, the defendants filed a motion to stay garnishment. The part B of the motion is that the garnishment was issued on an expired judgment. The plaintiff, strike, that defendant alleges that this judgment that was entered in 2011, that judgment is no longer valid because it's 15 years out from when it was first entered. That entry date was 5/16/11. The judgment, however, was renewed within the 10-year period. It was renewed not later than 5/10/21. And so the judgment was still valid at the time of the issuance of any garnishment in this matter. That is a factual mountain that does not easily move. Counsel, you've been at your appearance for Midland. I do not see counsel for defendant Weich. I have read the motion, and it's the sound of the motion. You may respond.
I'm sorry, I'm really having a hard time hearing you, Your Honor.
But I don't know what it is. It must be on your device or something, because I've had many cases this morning and everybody's heard me except you.
Maybe.
So the main thing here is that the attorney has not appeared on this matter on the motion. The grounding on the motion was that the judgment is expired.
Oh,
The
okay.
problem is the judgment is not expired. It was renewed in 2021 within the 10-year period.
Correct.
The attorney missed that or something. He said that because it was 15 years old, that enforcement could not be had on the judgment. That's not true where it's been renewed within the time permitted by law. So I think on a factual basis, the motion would have to be denied because that fact itself cannot stand. The reality of it is that the judgment is still valid.
Correct.
So anything you wanted to add at this time?
No, Your Honor. I mean, the total balance on this account now is just a little over $200, so this should be paid in full and taken care of.
Sounds good to me. All right. I'll deny the motion and look forward to the matter being resolved.
Okay. Thank you.
All right. Thank you. Good day to you.
You use the same.